Hi everyone, our topic is Republic Act number 10175 or the CyberCrime Prevention Act of 2012. So let's start with the definition of terms. So for the first term, you have their communication. So it refers to the transmission of information through ICT media, including voice, video, and other forms of data. And as far as computer is concerned, it is the electronic, magnetic, optical, electrochemical, or other data processing or communications device or grouping of such devices capable of performing logical, arithmetic, routing, or storage functions, and which includes any storage facility or equipment or communications facility or equipment directly related to or operating in conjunction with such device. So if you notice, it includes mobile phones, smartphones, computer networks, and other devices connected to the internet. So that is computer. When we say computer data, that is any representation of facts, information, or concepts in a form suitable for processing in a computer system, including a program suitable to cause a computer system to perform a function and includes electronic documents and or electronic data messages, whether stored in local computer systems or online. So that includes computer data. As far as the term cyber is concerned, that is referring to the computer or computer network. It is the electronic medium in which online communication takes place. Cyber. Cybersecurity, on the other hand, refers to the collection of tools, policies, risk management approaches, actions, training, best practices, assurance, and technologies that can be used to protect the cyber environment and organization and users' assets. So that is the cyber security. You also have there the definition for interception. It includes listening to, recording, monitoring, or surveillance of the content of communication, including the procuring of the content of the data. Database refers to a representation of information, knowledge, facts, concepts, or instructions which are being prepared, processed, or stored, or have been prepared, processed, or stored in a formalized manner intended for use in a computer system. So who are the so-called service providers? It may include both public or private entity that provides to users of its service the ability to communicate by means of a computer system, or it refers to other entity that processes, or stores computer data in behalf of such communication service or users of such service. The subscriber's information, it refers to you as far as your data is concerned. So it contains information contained in the form of computer data or other form that is held by a service provider. How about traffic data or the non-content data? So that is referring to any computer data other than the content of the communication, including but not limited to the communication's origin, destination, the route, time, date, size, duration, or type of underlying service. So it is referring to the underlying service with respect to the computer data that you have in the computer system. So let's proceed directly to the punishable acts under the cybercrime law. So section 4, for that matter, is actually sub-classified into 3 kinds of punishable acts. Okay, so these are section 4 only. It is classified into offenses against the confidentiality, integrity, and availability of computer data and systems. So I think there are 4 specific acts under 4A, and then you also have there the computer-related offenses, and then the content-related offenses. So what are they? So under 4A, you have there illegal access. Access to the whole or any part of a computer system without legal right. So we call that as illegal access. If there is such interception without right of any non-public transmission of computer data within the computer system, then we call that as illegal interception. Now take note that this falls under offenses against the confidentiality, integrity, and availability of computer data and systems. So you have their illegal access, illegal interception. What else? Illegal interference. So that is referring to the intentional or reckless alteration, damaging, deletion, or deterioration of computer data, electronic document, or electronic data message without right, including the introduction or transmission of viruses. So in other words, the act of the accused here interfered your use of the computer system, or it deteriorate, or it delete, or it damage your computer data. How about system interference? This is the intentional alteration or reckless hindering or interference with the functioning of a computer or computer network by inputting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or program, electronic document, or electronic data message without right or authority. And then you also have there misuse of devices. What constitutes misuse of devices under paragraph 4A? It includes the use, production, sale, procurement, importation, distribution, or otherwise making available without right of the following: a device including a computer program designed or adapted primarily for the purpose of committing any of the following. So computer password, your access code, or other data. So I think you have heard about the data breach as far as the COMELEC preparation is concerned, as to the use of these devices that shall be used for the upcoming election. So you have there the use of these devices that would hack, let's say hack, the computer password or access codes or other similar data in whole or in part of a computer system which is capable of being accessed with intent that it be used for the purpose of committing any of the following: possession of an item referred to in paragraphs 5I, AA, or BB above with intent to use said devices for the purpose of committing of the offenses punished under this section. And then you also have there the so-called cyber squatting. What is cyber squatting? You have there the domain of another, and you intentionally, without authority, motivated by bad faith, or to profit, mislead, destroy your reputation of the domain name of another through the following: you create a similar, identical, or confusingly similar to an existing trademark registered with the appropriate government agency at the time of the domain name registration. So meaning to say, you created a similar domain name of another, which is duly registered, that it pertains to A, for example. And here comes B, also creating a similarly confusing existing trademark, which is registered to A. Identical or in any way similar with the name of a person other than the registrant in case of a personal name. Or acquired without right or with intellectual property interest in it. So I think if you even try to put your name even on Facebook, there are actually similar, identical, or confusingly identical accounts as that of yours. So those are the crimes under 4A. So illegal access, illegal interference, cyber squatting, misuse of devices. That is 4A. How about 4B? On the computer-related offenses. So you have there computer-related forgery. What constitutes computer-related forgery? It includes the input, alteration, or deletion of any computer data without right, resulting in inauthentic data with the intent that it be considered or acted upon for legal purposes. The act of knowingly using computer data, which is the product of computer-related forgery. You also have there the computer-related fraud, which refers to the unauthorized input, alteration, or deletion of computer data or program or interference in the functioning of a computer system, causing damage thereby with fraudulent intent, provided that if no damage has yet been caused, the penalty is 1 degree lower. So if you will be asked, is damage really required before you can make one liable for cybercrime, preferably specifically on computer-related fraud? It's not required. For as long as you have there the unauthorized alteration or deletion of a computer program or data of another, then you are liable under section 4B, paragraph 2. And then further on paragraph B, you have there the computer-related identity theft. The intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical without right. That if no damage, then the penalty shall be 1 degree lower. Now take note that the case that I was able to prosecute under this act is that it was committed through Facebook. The Facebook account or profile of a particular person was hacked by another, and from that hack account, he made business to others. Business which in the long run became the reason why she was arrested, because there she posted something that she is into business. For example, that was ukay-ukay business. So from that particular account, he misrepresented himself to be that person engaged in that kind of business, and then she was able to have or to acquire money from those whom she transacted online. So what happened in that particular case is that she was asking for money for this particular product, and then when she received it, no actual money was actually delivered to the victims. So what happened? in that particular case, the buyer supposedly of that bulk, okay, bulk, send a message to that person, but it was to the original account of that particular person. So that's why when the accused was ultimately arrested, I feel pity on the real person because her name would really appear in the information. So for example, if you have there Maria and it was Anna who committed identity theft, she transacted online, thereby duping people. Example, A, B, and C. So here comes A, B, and C filing a complaint against Anna after she was arrested. But in the information, it would appear there in the people of the Philippines versus Anna or Maria, also known as Anna or vice versa. So see, if you are there, the real person whose identity was being taken by the culprits, your name would also appear in the information. I just cannot say with certainty on what would happen to them if they would apply for an NBI clearance, because definitely their name would appear there as an accused. So it would be a case as well, or a circumstance as well of hassle on the part of the victims whose identity were being taken by these perpetrators. Now 4C, content-related offenses. So we are talking with punishable acts with respect to content of this computer data. So included therein as content-related offenses, you have their cyber sex, child pornography, and then you also have their unsolicited commercial communications, and then libel. Okay. So what is cyber sex? So willful engagement, maintenance, control, or operation directly or indirectly of any lascivious exhibition or sexual organs or sexual activity with the aid of a computer system for favor or consideration. So basically, offering or engaging in sex through the cyberspace. So cyber sex. You also have their child pornography. So I think you can still recall what child pornography is. You have there the making or the production of pornographic material of a child or a purported child performing sexual or lascivious act through the use of the computer. So it says here, so if you will be asking, so what crime shall we charge against the accused, just in case he would be committing child pornography? So the law says that the penalty to be imposed shall be 1 degree higher than that provided for in Republic Act 9775. Now take note that since the overt act is the same as to the manner on how it is committed, it is very the same. So I would suggest that the charge against the accused shall be Republic Act number 9775 or the Anti-Child Pornography Act of 2009 in relation to cybercrime, paragraph 4C, because the penalty would be higher. And in fact, this was asked in the bar exam, in the recent bar exam. In the unsolicited commercial communication, so the transmission of commercial electronic communication with the use of the computer system which seek to advertise, sell, or offer for sale products and services Sale products and services are prohibited unless there is prior affirmative consent from the recipient. Primary intent of the communication is for the service and or administrative announcement from the sender to its existing user, subscriber, or customers. So if you have there without the prior consent of the recipient, then that would be constitutive of unsolicited commercial communication. But for now, nobody is taking the opportunity and time to charge someone despite the fact that they receive this so many commercial communication through online and even in your cell phones. I think because I myself even have received these unsolicited commercial communications. So if you have the luxury of time, you can might as well charge that particular person if you can caught him, if you can basically identify the perpetrator. So how would you do that? You can ask the help of the cybercrime to trace the IP address of the one who sent you. Ultimately, they will be captured, though it is time consuming. So you have there the qualification or the requirements before you can charge the person for unsolicited commercial communication. So if they contains the following: the commercial electronic communication contains a simple, valid, and reliable way for the recipient to reject receipt of further commercial electronic messages from the same source. The commercial electronic communication does not purposely disguise the source of the electronic message, and the commercial electronic communication does not purposely include misleading information in any part of the message in order to induce the recipients to read the message. So take note that the following conditions are present. So all of them has to be present. So as to the implementation of this, the law may be very nice, but as to the prosecution and the implementation, it's another story. What is cyber libel? The unlawful or prohibited acts of libel as defined in Article 355 of the RPC, if the same is committed through a computer system or any other similar means which may be devised in the future. So for purposes of filing a person or charging a person for cyber libel, you have to make reference to Article 355. So you have there the elements of libel. So you have there the malicious imputation, and then there is publicity, there is malice, there is, if the same is committed through the ICT or the information computer technology, then you can charge him for cyber libel under this particular act. Because if the same is not committed through the ICT, then you have there 355 of the RPC. And this is actually overused by some, especially those usually committed through Facebook. Okay, so there are so many libelous things that is happening there. Do you have there the jurisprudence of just mere sharing and even liking cannot make you liable for cyber libel. But if you have there a malicious article, not only that you share or like, but you also made your comment on it, which is defamatory in itself, then that would be the time that you can be made liable for libel because you actually subscribe to the malicious or defamatory article that you shared as well online. So that's why please be careful on before sharing these articles. But as what I have said, mere sharing is not actually libelous as punished under the law. So it is on the moment. If you are not the originator, you just share it. Okay. So I forgot the particular jurisprudence, but I think I included it in the bar material review materials of the Recoletos review. I'll just send it to you when I will have it. So are those the only acts punishable under the cybercrime? Now we have their section 5, which punishes other acts of cybercrime like aiding or abetting the commission of cybercrime, and then attempt in the commission of cybercrime. So they are all governed by section 5. And lastly, you have their section 6. In section 6, it is a provision which provides that for all crimes punished and penalized under the RPC and other special laws, if the same is committed with the use of the ICT, information and communications technologies, shall be covered by the relevant provisions of this act, provided that the penalty to be imposed shall be 1 degree higher than that provided for by the revised penal code as amended and special laws as the case may be. In other words, while there are only few punishable acts enumerated under the law, Section 6 actually punishes all other crimes defined and punished under the RPC, as well as other special penal laws committed through the use of ICT. Take note of Section 6. That is a qualifying circumstance wherein the penalty 1 degree higher shall be imposed upon you. So, any acts committed through the ICT, punished under the RPC and special laws, the most accurate or the designation that you shall use in the filing of your complaint shall be that felony or crimes as punished under the RPC or the penal laws in relation to cybercrime, specifically Section 6, so that the penalty would be higher. But the charge shall be under the RPC or the penal laws. You just put there in relation to. Liability under other laws, a prosecution under this act shall be without prejudice to the liability for violation of any provision of the RPC as amended or special laws. So, though you have there the discretion, and it even says without prejudice, but sometimes the victims opted to charge, or the police officers opted to charge them under that particular RPC provision or the penal laws, and then they will say it in relation to. Let's proceed with the penalty. If the accused is charged under 4A and 4B, the penalty shall be prisión mayor or a fine of at least 200,000 up to the maximum amount commensurate to the damage incurred or both, such imprisonment and fine. If the accused is charged under 4A paragraph 5, the penalty shall be prisión mayor or a fine not more than 500,000 pesos or both. If the accused is charged under 4A and it is committed against critical infrastructure, the penalty shall be reclusión temporal or a fine of at least 500,000 pesos up to the maximum amount commensurate to the damage incurred or both. at the discretion of the court. If he is charged under 4C, paragraph 1, you have there the penalty, that is for cybersex. If it is 4C2 on the anti-child pornography, then the penalty of the child pornography shall be imposed, and then we have to base the penalty on the provision under RA 9775, and then the same shall be imposed 1 degree higher than that provided in RA 9775. If the accused is charged under 4C3, he shall be penalized for an imprisonment of aristo mayor or a fine of at least 50,000 pesos but not exceeding 50,000 pesos but not exceeding 250,000 pesos. If he shall be charged under section 5, then the penalty shall be 1 degree lower than that prescribed for the offense and a fine of at least 100,000 pesos but not exceeding 500,000 pesos or both. If the offender is a juridical person, who shall be made liable? So the following shall be made liable. Those who knowingly committed on behalf of or for the benefit of the juridical person shall be made liable, provided that the act committed falls within the scope of such authority, and then the authority to exercise control within the juridical person shall be held liable for a fine equivalent to at least double or fines imposable in section 7. What does this proviso would tell us? That if you have there authority granted by the juridical person to the natural person, then this would the proviso shall apply. If the same is committed through the lack of supervision or control by a natural person referred to and described in the preceding paragraph, meaning to say the same was committed because of his recklessness or through his negligence, then the penalty shall be held. It's the corporation who shall be impose a fine equivalent to at least double the fines imposable in section 7. So if you notice, if it is the juridical person that shall be made liable, the penalty is only fine. There is no imprisonment because you cannot put in prison a juridical person. The liability imposed on the juridical person shall be without prejudice to the criminal liability of the natural person who has committed the offense. Now take note that section 13 provides for the preservation of computer data. So the integrity of computer data and subscriber information relating to communication services provided by a service provider shall be preserved for a minimum period of 6 months from the date of transaction. So that is 6 months. So if you are the one being aggrieved, you have to write a request to the service provider so that they can at least preserve for you the subject computer data that you needed for purposes of the prosecution of this crime. Law enforcement authorities may also order a one-time extension for another 6 months. So the mere furnishing of such service provider of the transmittal documents to the office of the prosecutor shall be deemed a notification to preserve the computer data until the termination of the case. The service provider ordered to preserve computer data shall keep confidential the order and its compliance. Now take note of section 15. Search, seizure, and examination of computer data. Now take note that section 15 can only be done, for example, by the police officers, specifically those in the cybercrime unit. They may search, seize, or examine a computer data only once they shall be issued the what so-called is cybercrime warrant. So there must be a search and seizure warrant properly issued before the law enforcement authorities can do the following within the time period specified in the warrant, to secure a computer system, to make or retain a copy of the computer data, to maintain the integrity of the relevant stored computer data, to conduct forensic analysis or examination of the computer data storage, to render inaccessible or remove those computer data in the access computer or computer and communications network. Later, we'll talk about the cybercrime warrants in the conduct of the search, seizure, and examination of computer data. As to the custody of computer data, all computer data, including the content and traffic data, examined under the proper warrant, shall within 48 hours after the expiration of the period fixed therein be deposited in the court in a sealed package and shall be accompanied by an affidavit of the law enforcement authority executing it, stating the dates and times covered by the examination and the law enforcement authority who may access the deposit, among other relevant data. In other words, if the police officer would apply for a cybercrime warrant from the court, within 48 hours, they had to make a return after the implementation of the warrant. Destruction of computer data, when shall it be done? The law says immediately and completely destroy the computer data subject of a preservation and examination after the expiration of the period provided under section 13 and 15. Okay, after the expiration of the period of its preservation, thereafter it should be destroyed. Exclusionary rule, that any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. In other words, the same shall be considered as fruit of the poisonous tree, hence inadmissible in evidence. Who has jurisdiction? You have their RTC. And actually, we have there the RTC designated as Cybercrime Court. Okay, designated as Cybercrime Court. Now, as far as the cybercrime warrants is concerned, we have to relate this to administrative matter number 17-11-03-SC. So this is the rule on cybercrime warrants. It set forth the procedures for the application, as well as the grant of warrants and related orders involving the preservation, disclosure, interception, seize, seizure, and examination, as well as custody and destruction of computer data. But you will just have the details on this in your remedial law. What I'll show to you are what are these so-called cybercrime warrant, so that the law enforcement officers can do the seizure, the seize, or in the examination or forensic examination for that matter of the computers that were subject of the investigation allegedly committed, allegedly used in the commission of the cybercrime. So what are these warrants? Warrant to disclose computer data, warrant to intercept computer data, and the warrant to search, seize and examine computer data. So these are the cyber crime warrants that shall be secured by the law enforcement officers prior to their actual the disclosure and interception, if they are still having, let's say, surveillance, or at the moment that they want really to caught in the act the perpetrator of the perpetrator on the commission of cybercrime, then you have these two warrants. And then if they, after they actually arrested the accused for the commission of a cyber crime, for them to open the particular device used in the commission of cybercrime data, they have to apply for the warrant to search, seize, and examine computer data. Okay, so possible question on this particular law for your purpose. What is cybercrime? And then take note that Section 6 provides that acts or omissions punished under the RPC and other penal laws with the use of the ICT. It says there that the penalty to be imposed shall be 1 degree higher if the act or the felony is punished under the RPC or the penal law. Then what is a cybercrime warrant? So you have there the 3 cybercrime warrants. So at least you are familiar on what are these warrants. So that's all for the law, the Cybercrime Prevention Act or Republic Act number 10175.